The Freedom of Information Act allows people to get information that the government agencies have in their possession, subject to a few big exceptions. Now, what if that information is about you? For example, let's say that while they were investigating someone else, maybe an acquaintance of yours you've met only once or twice, government officials or investigators also did some digging on your background to see if you were involved, concluded that you weren't involved in the wrongdoing they were investigating, but in the process uncovered some details about you that you would find embarrassing if they were made public or maybe even incriminating. That's the basic plot of the case we're going to be looking at in this video: the Electronic Privacy Information Center versus the U.S. Department of Justice, or EPIC versus DOJ. This is a 2021 case from the D.C. Circuit Court of Appeals. I'm Drew Stevenson. This is for my administrative law class. Let's dive in. So in 2017, in response to rumors and reports that were circulating, the Attorney General appointed Robert Mueller as a special counsel to investigate Russian interference in the 2016 presidential election, and specifically to determine whether anyone associated with Trump's campaign had been involved with or had worked with the Russians in that regard. So the investigation lasted a couple years, and in 2019, Robert Mueller concluded his investigation and provided Attorney General William Barr with a report detailing his investigation and conclusions. And then Attorney General Barr reported to Congress, without releasing the report, that the report had basically cleared everyone associated with the Trump campaign from having anything to do with the alleged Russian interference. Attorney General Barr also told Congress that the Mueller report had concluded that the evidence developed during the investigation was not sufficient to establish that by then President Trump had obstructed justice or tried to cover anything up during the investigation. But Special Counsel Mueller disagreed. He didn't like how this had been characterized by William Barr publicly, and said that his report and public statements did not fully capture the context, nature, and substance of Mueller's conclusions, and that Barr had created a lot of public confusion about the results of the investigation. Even so, Attorney General Barr reiterated his comments in press conferences and interviews and so forth over the following weeks. And then Barr published a heavily redacted version of the Mueller report, and many names were redacted from the appendices in particular. So our plaintiffs in this case are BuzzFeed, the news outlet, and the Electronic Privacy Information Center, or EPIC, and they submitted FOIA requests to the Department of Justice seeking a copy of the unredacted version of the Mueller report. The DOJ didn't release it to them, and so they sued, and when sued, then the Department of Justice invoked several FOIA exemptions, including FOIA Exemption 7. The only FOIA exemption at issue on appeal was Exemption 7C, under which the government does not have to disclose information if disclosure would violate the privacy interests of individuals. Here's the text of FOIA Exemption 7C, just to look at the wording itself. FOIA does not apply to 7, records or information compiled for law enforcement purposes, but only to the extent that production of such law enforcement records or information could reasonably be expected to constitute an unwarranted invasion of personal privacy. Now, courts have developed a two-part test for analyzing or applying FOIA Exemption 7C, the section that I just showed you. And it's basically two prongs. Disclosure would, quote, reasonably be expected to constitute an unwarranted invasion of privacy. And then secondly, that the personal privacy interest in the case is not outweighed by the public interest in disclosure. So notice this is a balancing test. Other sections of FOIA do not necessarily use this type of balancing test. There's some details about who has the burden of proof in these FOIA cases that students should pay attention to. Under FOIA, the government agency bears the initial burden of establishing that a claimed exemption applies if it wants to deny a FOIA request that is otherwise valid. So if a person files a request that, at least on its face, looks like a valid FOIA request, the burden is on the government to show that one of the exemptions allows them to refuse the disclosure. Otherwise, they have to turn the information over. Now, under 7C, the burden can shift back. So let's say the government shows that there is a privacy interest, and that's why they don't want to have to disclose these records that are related to a law enforcement investigation. In that case, then the party that's seeking disclosure, the other party, has the burden of showing that there's really a significant public interest, not just their own private interest or curiosity in having the information. And furthermore, that information they're asking for is likely to advance that public interest. Now, the district court in this case had sided entirely with the Department of Justice. But here, the D.C. Circuit Court of Appeals applies the exemption to some of the redacted information in the Mueller report, but not all of it. So the court notes that some of the redacted passages contain no new facts or information that had not been made public elsewhere in the same report. And just to explain the procedure here, when we have a challenge, especially under this particular FOIA exemption, the judge is going to review the unredacted materials or the disputed materials in camera or privately. So they're going to see what it is that the government thinks no one should have or that shouldn't be disclosed to the public, and can make a decision about whether the FOIA exemption applies. So they don't just have to take the government's word for it that the FOIA exemption applies, at least when it's exemption 7C. And so the court did that here. And when it saw the unredacted version, it decided that some of the names and so forth that they were redacting, anyone reading the rest of the report already could at least piece together that type of information. Not all of it, but some of it. There was other information that revealed some new facts or information about individuals that was not otherwise known or revealed in the remainder of the Mueller report, and that the court thought could be stigmatizing or somehow harmful to the individuals mentioned if it was revealed to the public. So one of the big takeaways from this case is that the court uses a balancing test, weighing the privacy interest at stake here against the public interest in having the information made public. And note that the court goes into detail about what the public interest is here. They're saying the public interest is not just knowing these facts about these people, like what did these different members or associates of Trump or his campaign or his family do or say during the investigation. The public had an interest in knowing whether Robert Mueller had conducted the investigation diligently or if he had been biased or things like that. There were a lot of questions and criticisms from really both parties against Mueller for how the investigation had been handled. The court felt that there was an overwhelming public interest in knowing how Mueller had made decisions that certain information mattered or that certain people's testimony was relevant or not relevant or conclusive or not conclusive. So let's talk about the court's holding in this case. For the categories of redacted information in the report that were basically facts that were revealed elsewhere in the report in an unredacted form, the court thought that there was no real privacy interest anymore, or at least it was a significantly reduced privacy interest, and that the public interest at stake far outweighed the privacy interest. The implication is that Exemption 7C did not apply to those redacted sources, and the information, therefore, had to be revealed or disclosed to the plaintiffs. But for the second part of the court's holding, it said that for redacted information in the report that would have been new or new facts that were not otherwise disclosed elsewhere in the report, the balance tipped in the other direction. And in terms of the privacy interests, outweighed the public interest, and therefore Exemption 7C did apply, and the DOJ did not have to reveal the information. So where does this leave us? Well, I want to make sure my students understand that the DC Circuit's decision demonstrates a rather nuanced application of FOIA Exemption 7C. It's not always clear cut. It's going to be rather fact intensive, sometimes a case by case determination. And it highlights how the balance between public transparency and individual privacy is determined on a case by case basis or a sort of ad hoc basis, heavily influenced by not only the parties involved and the public interest at stake, but the specific content that's being withheld. And that concludes our discussion of the case, the Electronic Privacy Information Center versus the Department of Justice. Thanks for watching.